Now, under the current law, an agent under Chapter 709, attorney in fact, is a fiduciary who must observe standards of care and bound by the Prudent Investor Act. Now the Act provides very specific mandatory default duties for the agent, and then mandatory acts and default modifiable duties, so that I can say I can add language to my power that says that I specifically authorize my attorney in fact to self-deal. If I don't do that, there is a duty to act loyally and to avoid conflicts. That's a modifiable duty. A mandatory duty that I cannot draft around would be, for example, the duty to preserve my estate plan if I'm the principal. Now, more on this later, because modification of estate plans and creation of trusts and testamentary dispositions is a big change in the statute I'm going to get to in a moment. Now, the authority of the agent. An agent may only exercise authority specifically granted to the agent in the power of attorney. Well, that sounds pretty normal and must have always been that way. But in fact, in Florida, it was very common to include a provision in the power of attorney, a very general delegation of authority. If I can do it, you can do it. That specific, or that rather general delegation of authority is not valid. We have to be very specific about the acts that we're allowing, and there's no default abilities that a power of attorney would have without that specific language. Whether or not we authorize a power of attorney, we can't draft around certain things. We cannot authorize an agent to perform personal services of the principal. We cannot authorize an agent to vote in a public election on the principal's behalf. These are things that existed before. The banking and investment powers. Power of attorney that states that one drafting issue that we've always had is needing to specify all of the different transactions that a power of attorney may need to do. Now, under the new statute, we're given a much cleaner way of handling that. We point to a specific statute subsection and say that the attorney in fact has all of the authority granted for investment powers under 709.2209 or for banking powers under 2208. And by stating that, we mean the following. 709.228 automatically establishes, continues, and modifies, terminates an account or other banking arrangement with a financial institution. It allows the attorney in fact to contract for services available from a financial institution, including renting a safe deposit box, withdrawing monies, receiving statements, all of the things that we typically would look at as normal and ordinary banking. So we don't need to specifically mention all of those provisions anymore. We may want to in our drafting because we know that the teller at the bank is not familiar with 709.2208, and it may still be prudent to include that language in there. But even if it's not in that document, there's this default standard now, and that's important. One thing that 2209, which allows for the investment powers, specifically excludes would be commodity trading, call and put options, and things like that. So we'd have to draft through that. Now, 709 now includes what we call superpowers. And here I was going to be on my shirt and show the big S on it. I don't have one, but I'll tell you that the superpowers are about estate planning. And these are issues that have come up in really interesting cases that have come up before Florida's District Courts of Appeal, because the statute before was not clear on whether or not an attorney in fact could make changes. Under current law, under the past law prior to October 1st, it stated, an attorney in fact may not create, amend, modify, or revoke any document or other disposition effective at the principal's death, or transfer assets to an existing trust created by the principal unless expressly authorized by the power of attorney. And where the fighting has come in is whether that last term, unless expressly authorized by the power of attorney, modifies just the last clause or the whole clause. If it modifies just the last clause, then it's saying that I can authorize transfer of assets to an existing trust by expressly authorizing it. If it modifies the whole clause, then I can modify, amend, create, or revoke any document or other disposition effective at the principal's death. That's a very big difference. And there's a split of authority. So the statutes now deal with that. The Act now clearly allows a principal to grant authority to the agent to take significant actions that can impact the principal's estate plan or gifting program. So, but because these are such big deals, superpowers, these superpowers must be specifically authorized in the power of attorney and even specifically initialed by the principal. The law wants it to be very clear that the principal is giving the attorney, in fact, the ability to make these very big changes. I'm allowed now to authorize in the power of attorney that my agent may create and fund a revocable trust on my behalf. I can say that and if I do that, the principal must sign or initial next to each specific provision, each enumeration of the authority. The agent may only exercise the authority consistent with the duty to preserve my principal estate plan pursuant to 709.2114. Now, if we look at 709.2114, which I have here, the bill, 709.2114 says, I must only act as an attorney, in fact, within the scope of authority granted in the power of attorney, and in exercising that authority, I may not act contrary to the principal's reasonable expectations actually known by me. I may not act in any manner that's contrary to the principal's best interest, and I must attempt to preserve the principal's estate plan to the extent it's actually known by me. Well, there's a lot of wiggle room here, folks, and so we anticipate that there will be legislation that helps to define this language more. But it looks like, for example, if I'm doing Medicaid planning for a client, and the principal, the grantor, the settlor, has stated that everything goes to my spouse, but the spouse is going to be on Medicaid or is on Medicaid, and we would like to do something different. The question is whether that would still be consistent with the principal's estate plan. And a very good argument could be made in many cases that it is consistent, even though that may not have been written in the document that way. In fact, if it's not written in the document that way, that would be the only reason why we would need to ever make changes is because we need to clarify. So those are going to be opportunities, lawyering opportunities, and I expect that there will be some controversy over them. The powers that may be granted to an agent with these superpowers would be the right to create or amend or modify a revocable trust, to make gifts. Now, there are some restrictions. The default is that we cannot exceed the gift exemption amount, but we can draft around that and allow for greater gifts. We can create or change right of survivorship. We can create or change a beneficiary designation by specific authority, remembering that these must be initialed or signed. That's a big change in the law. So execution requirements are different. Now, if you're an out-of-state attorney and you're drafting a power of attorney for a client that's going to be coming back and forth snowbirding to Florida, certainly the preference is that they do Florida documents and maybe documents in their home state. But if in the absence of that, these provisions are going to need to be in their foreign document in order to be recognized in Florida, and they're going to have to be executed with the same formalities of execution. Now, another big change, and then I'm going to close. I mean, there's other issues, and if we had time, I'd go through every one of them with you. But I want to highlight the big ones. There's new requirements on how powers of attorney are accepted by third parties. Now, one of the big changes in 1995 was it gave teeth to the attorney in fact. If I went to a bank and the bank refused to honor my power of attorney, which happened all the time, I had no recourse prior to October 1st of 1995. Now, after October 1st of 1995, with new compliant powers of attorney, I was able to go to the bank, and if they unreasonably refused to accept my power of attorney, I was able to get attorney's fees, court costs, and damages. That's still the case under the new statute, but it's made even tighter. It now says that I can present that to any third party. If the third party wants more clarification, they're able to ask me as the principal to provide them with a legal opinion stating that the particular action I'm asking them to take is authorized under the power of attorney. Now, the principal can request from the third party their request in writing. So the third party must give you a written explanation of why they're asking for clarification and therefore are delaying their authorization to act. Beyond that, if it's a foreign power of attorney, the statute specifically states that an out-of-state power of attorney brought to Florida, presented to a third party, that third party can always request a Florida legal opinion from the principal, and that must be provided on the principal's dime. So one of the things that a drafting option for out-of-state counsel would be to include language in the power of attorney that makes this option clear to the third party. Without that language, the concern is that the third party is going to refer it up to their legal department in another state, unfamiliar with Florida law, and we see this happen quite frequently, whereas the principal's attorney could have, or principal's attorney in Florida, could have given a legal opinion that would have clarified the problem very, very quickly. So we want to make it clear to the third parties that they have the ability to request this legal opinion and request grounds for additional information. If they refuse the power of attorney, they must do so in writing. And now there's a reasonableness standard in terms of time. It's deemed reasonable to take 4 days to determine whether the third party is going to accept the power. They can't go on an interminable amount of time debating within their legal department whether it's valid or not. No more. There's a reasonableness standard attached to it. So we're very happy to see that. Under the prior law, an affidavit could be requested by the third party, and that's still the case now. There's liability for this improper rejection, just like in the past. So we're very pleased with these changes in general. It's a good thing for a consumer lawyer to be able to protect our clients better, to be able to draft in more authorities into the document. If you're out-of-state counsel, I hope you'll be able to take this information and use it to better the powers of attorney for your Florida clients, or preferably to let them do new powers of attorney in Florida and have their home powers of attorney, and that way they're protected in both states with the full power of law under those state rules and laws. Everything's so different. These laws are very state-specific. So thank you for listening, and if there's any questions that you have, feel free to go to our website where we have more articles on powers of attorney, and you can always call. Thank you.